Maybe resolution. Yes. Item number two, my lord. I need 1 week's time, my lord. Maybe next week, my lord. Any day.
On the pair of Mr. Ahmed Leonard Counsel appearing for the petition of Mr. Rajathan Premi.
I beg to mention item number 11, my lord, hearing matter. Matter we adjourn for the my lord. The youngest country is out of station, my lord.
Who is out?
As hoc, my lord.
Wait for your turn. It's 2019 matters. We're in 24. Wait for your turn.
Please, Your Lordship. My Lord, I beg to mention item number 4, 5, and 6, my Lord. My Lord, the lead counsel, Mr. M.U. Mahmood, due to some urgent reasons, had to leave for Boinga today in the morning, my Lord. But we have taken consent from the other side. My Lord, these matters may kindly be passed over for the day, my Lord.
Wait for your turn. So just proceed.
May I please, Lordship? Lordship, I beg to mention item number 7, Lordship. My senior, Mr. M. Chandra, supposes to do the matter today, Lordship, but he had done his cataract surgery on last week, Lordship. Therefore, Lordship may kindly grant 4 weeks time.
Well, I'm for the petitioner, my lord. I'm also been newly engaged to proceed with the matter, my lord.
We have informed the other
Yes,
side,
I'm for
Lordship.
the other side, my lord. I have no other side. Even I've been appointed newly, my lord.
You have not yet filed your Okarat now?
Well, I'm the standing counsel for the corporation, my lord.
Okay.
Well, my name may also be reflected in the causes.
Give us a date. The matter is of 2019. Give us a date.
Lordship, any date in a month of February. On the last week, Lordship, of February.
It is submitted at the council for the respondent, Mr. M. Chakka, Sachin, and his eye surgery, and a subscribe has been made for 3 weeks. With concept of the council petition. Prayer allowed. List on 22/02/2024 for hearing.
Well, my name may be reflected in the causes, my lord. I'm Smith.
It is submitted by Mr. M. Smith that the is the standing counsel for the Employees State Insurance Corporation. I, the petitioner, and has been newly engaged. His name may be shown in the causelet under the petitioner's column in this matter. Registry shall reflect the
Obliged.
Hey, please, Lordship. I beg to mention item number 12, ma'am. Pass over for the day, ma'am.
wait for your turn. Let's see.
May I please, your lordship? My lord, on last occasion, my lord, this honorable court has been pleased to ask the petitioner to obtain a certificate regarding the name of change of the village of the petitioner, my lord. My lord, there from revenue authority, he could not obtain that certificate. If your lordship peruses the order dated, my lord, first order, my lord. 15/3/2019, my lord. And otherwise, my lord, other documents, my lord, that has been relied upon by the petitioner before the tribunal, my lord, that indicates that, my lord, the Mahabir Pathar village where the petitioner is presently residing, that was initially a part of the Jor Simolo Gosputa, my lord, the other village.
Heard Mr. D.P. Bora, counsel appearing for the petitioner. And Mr. J. Pang, standing counsel from Department of Assam, for the respondent number 2
Six.
and 6. Mr. H. Kohli, standing counsel, learned counsel on behalf of Mr. AIL, standing counsel, Election Commission of India, for the respondent number 4. And Mr. Taluga, Art Taluga, Government Advocate Assam, for the respondent number 5.
And my lord, one vital fact I would like to point out before your lordship, my lord, I have filed an additional affidavit, my lord, wherein the brother of the petitioner has been declared to be an Indian national by another tribunal, my lord.
In a reference being made by the Superintendent of Police Porter Kamrup, the learned member of Foreigners Tribunal, second Kamrup, Real Popo. At Popo. After hearing the petitioner, considering the evidence adduced by him, and on hearing the other parties of the another party, by its opinion dated 27/08/2018 in BFP case number 3848 of 2016, declared the petitioner to be a foreigner. Impugn opinion dated 12/6/2008. Remember for bill number 1. At Guwahati. Declared the petitioner to be a foreigner. Oblique illegal migrant. Sir, for under the Foreigner Act 1946, and an illegal migrant of post 25/03/1971 for illegally entered territory yet on the specified territory of Bangladesh. Here, on or after 25/03/1971. Dissatisfied with the said opinion, they get such and such action of violation on (11 12/2018) by filing an additional affidavit. Petitioner placed before the court that his brother in a similar position Nasir Ali alias Nachir Ali, alias NHHPRL. By opinion dated 27/08/2018 of the foreigners travel number to Kamrup Rural in BFP case number 38 of 2016. Found him as not a foreigner and rather an Indian national. It should not be sleeping over the That's it. No problem. As the petitioner has been declared to be a foreigner under the Foreigner Act. Fine. Okay, take that. He shall appear before the Inspector of Police on or 16/02/2020 or JFP case number 807. JFP would indicate article case number 807 of the office of Land Member of Foreign Establishment Kamrup Rural number 1. That was as well as the records of BF case number 3848 of 2016 disposed of on 27/08/2018 in the office of the Land Member of Foreign Establishment.
Lordship has been placed to grant bail, my lord.
That's already there. You appear before the Supreme Court.
Yes, my lord, yes, sir. In this case, my lord, your lordship has been pleased to direct for a listing of this case along with the earlier writ petition, my lord, of 2003, my lord.
Mr. Payang, the petitioners herein were the petitioners of the writ petition WPC number 7093/2003. They were the petitioner numbers 4 and 5. Do you have a copy of this writ petition?
Yeah.
Do you have a copy of this?
Yes, my lord. Which one, my lord? 5415. It's
You have. Now come to page number 59.
last page, my lord.
That was the writ petition they preferred.
Yes, ma'am. 709.
You can see their name at page 58.
Yes.
Earlier we passed an order. Mr. Kolita was there. It was an order of November 2019. They apprised the court what is the outcome of the same. Thereafter, we passed another order on January 29. Anyway,
Yes.
from October 2019, we do not know. 4+ years. So tell us what is the outcome? When?
But,
The matter was
On-
supposed to be placed before
on
the
8, my
appellate
lord.
authority.
on 8, my lord.
No, give us a date where you
On-
can really go.
Yes, 8 of February, my lord.
Sure,
Yes, ma'am. I'll try to get whatever is there.
but it was to be disposed of by the appellate authority. So find out.
Yes.
On the prayer of Mr. J. Pang, standing counsel on the part. Please
Then your lordship may kindly give some more time, my lord, in that case. Last week of February, my lord.
No, no.
Then let it be on 8. Let me try on 8, my lord. Then if no. Hmm? No, that's very good. Let it be on 8, my lord.
Placed on 8. J. Pang, standing counsel on the part. To apprise the court about the status of the appeal. Preferred by the petitioner against the judgment dated 23/12/2002 passed by deed and illegal migrants within bracket D tribunal. Ojai Sankadev Nagar. In case number IMDT oblique H oblique 290 oblique 90. In terms of the order of report dated 11/11/2003, passed in WPC number 7093 oblique 2003. Annexer 17 to this petition. As directed earlier on 27/11/2009.
Oblige, my lord.
May I please your lordship? Ilchair was called for, my lord. Ilchair has deceived, my lord.
Take your seat.
My
Order तीनटा है.
Please, your lordship. My lord, these are custodial death matters. 4, 5, and 6.
You said Mr. Mahmood hasn't reached Guwahati.
No.
Yes, yes, look at this. Itu bringing a message. Itu tunggu boleh balik. Itu connect. Itu bawa kita jelas mah. Kita jelas kita buat itu encounter mah.
কেতিয়াই লৈ এতিয়া প্ৰব্লেম পাই আছে আৰু প্ৰব্লেম হৈ গ'ল ইনডেক্স আমি আপডেট কৰি লৈছোঁ
When do you want?
Or any day.
Hmm. 15.
There's a small prayer, my lord.
Minimum 15 my lord, on 22nd my lord. 22nd is a Thursday.
On the prayer of the council for the parties, please come 22nd.
20, 22nd. আমার call করুন। ওটা কেটে নিন। All 4 to 6 all my lord.
All.
Lol. Problem.
Mr. Nat and Mr. What's your good name?
SH Mahmood, my lord.
Prepare the date sheets and that will help us.
Problem. Okay. May I please, my lord? My lord, LCR has been GC'd, my lord. Earlier LCR was called for.
Mr. Sikh, take your seat.
My lord,
Take your
obliged, my lord.
What is the name of your father?
My-
As per the written statement,
Yes, my lord. My lord, there is some discrepancies in the name of my father,
what
my
is
lord.
your name of father as you have mentioned in your written statement?
My lord. Well, son of Abdul Rahman alias Abdul Rahman.
So you have
That is-
projected your father as Abdul Rahman
Yes, my lord.
and mother as Ahatan Nisa.
My lord.
Right.
My lord. Earlier, my lord, there is discrepancies in the year voter list of 1966. My lord, my father's name was recorded Rahman Ali. But here I have explained in the
What is the
written
name of your grandfather?
grandfather, my lord. Grandfather, my lord. Correct name, my lord, Toyovali, but somewhere it is written, my lord, it is recorded Tom Toyovali, my lord, Toimur, my lord, like this. So 1979, my lord, it is written Toyovali. 1966, it is written Tom, my lord, Tom. Nineteen 1970 also my grandfather's name it is written my Tom. But in the 1970 9 voter list, page 35, my lord, it is written Toimur, my lord. My father's name written Abdul Rahman. My mother's name Ahatan Nessa, my lord. My father's name only Rahman is shown in against my father's name, my lord.
First of all, this is not a
My lord.
certified copy, Annexure 4.
Annexure 4, yes, my lord. 1979, it is an extract copy, my lord. It is the original one, my lord. It is issued by the government. It is not certified copy. It is true, my lord. But it is annexed in the written statement, my
You can
lord.
read vernacular.
My lord.
You can read vernacular.
Yes, my lord.
You can
Vernacular
read-
79 page, answer for my lord, page number 37. My father's name and
No,
my
you can read vernacular, right?
vernacular, my lord. Vernacular, page 37, my lord.
No, we'll come to that later.
Yes, my lord.
Page 29.
Page 29, my lord. Page 29, my lord, 1966 voter list. Vernacular, my lord.
What is the name of the village?
My lord, village Laruazan.
Village is Laruajan.
Right,
What is the
ma'am.
Moja?
Moses, my lord, Pup Samoria, Thana, Soigaon.
Very good.
Yes, my lord.
Now,
My
the
lord.
voter list of 1970,
70, my lord.
page 34.
My lord. Page 34, original certified copy, my lord. My lord, Gao, my lord, village is Laruajan,
Hmm.
Moza, Pup Samoria, Thana, my lord, Soigaon.
Now, you are saying
Yes, my lord.
of 1971 voter list,
79
voter list.
my lord, 79 voter list, my lord.
Name of the village.
Yes, my lord, this is, my lord, it is written Lakuazan. My lord,
It
there
is
is
not, it is Lakrajan.
Mm.
Or
Yes.
Lakwajan.
Lakuazan, maybe, my lord,
What is the
Lakuazan.
Moja?
Moza, my lord, Goroimari, my lord, Thana, Soigaon.
So,
Thana is same, my lord. School is same, my lord. Only village name shown is Lakuazan. Maybe, my lord, it is spelling mistake, my lord. For this, my lord, your lordships, this honorable court directed, my lord, the authority to verify, my lord, regarding this village, my lord. As per order dated, my lord, the lordship's order is there. My lord, order dated 15/5/23, your lordship's order. And also, my lord, directed the superintendent of police, my lord, to verify and make a report regarding the discrepancies of name of
see,
my
you
father,
might have,
of my father's name,
see, you might have seen
my lord,
the judgment passed earlier by this court,
my lord,
as well as the judgment of the apex.
my lord.
Which document proves before the tribunal
Yes, my lord.
that one R. Rahman, you are saying
R.
Abdul
Rahman.
Rahman,
Yes, my lord.
son of Toyоб Ali, whose name figured in the voter list of 1985,
Yes, my lord.
is the son of Toum, whose name figured in the voter list of 1970 as well as 1966.
66, my lord.
How you have connected it?
Yes, my lord.
By which exhibit? By which?
Yes, my lord.
What kind of evidence?
My lord, it was not submitted before the learned tribunal, but before this honorable court, my lord, as per honor lordship's order, I have filed the additional affidavit bringing the my lord lands documents, my lord. Wherein, my lord, Toimur, my lord, it is clear grandfather, and wherein my uncle's name in the elder uncle's, my lord, Innos
That
Ali,
was of which document?
my lord, in additional affidavit, my lord, I brought
Was it
some.
which date of the date of the document?
My lord, lands documents, it is, my lord. It's a government document, my lord. Affidavit, my lord, additional affidavit filed by me, my lord. Page number, my lord, 119 also, my lord. Wherein my name also subsequently we have inherited the properties of my father's, my lord, and our brothers and sisters' name is included, my lord, in the government record. Page 119, my lord. Here also, my lord, the authority wrongly written my name that is the petitioner's name, Tahaz Udadin Abdur Rahman. Somewhere mistakes done by the government, my lord. For this, my lord, the petitioners. And the original Jababundi, wherein my father's name and my uncle's name is incorporated, my lord, page 116, my lord. It's a type copy, Parnacolor, my lord, 116A, my lord, in my additional affidavit. It's only filed to show, my lord, to establish that Innos Ali in 1966, my lord, is my elder uncle, my lord, and Toyobali or Toimur, my lord, is my grandfather.
Are you sure?
Yes, my lord. My lord, these land documents I have found subsequently before when the pending this petition, my lord. Not before the tribunal, I could not get, my lord, not furnished to me. When my lord, this honorable court asked me to bring some record, my lord. The land documents, my lord. Land documents, my lord, it's a written, my lord, the date from where they are possessing, my lord, in the remarks part, page 116A, my lord, I am talking, my lord. I am submitting, my lord. Here, my lord, 1969 documents, my lord. My lord, remarks number 4. May I read, my lord?
Hold on, hold on.
Yes, my lord.
One one six A, page annexure 26.
My lord.
This is Pata number 27.
My lord. Pata number 27, notun, my new, my lord. Yes, my
Read on the right side under a remark column.
remark, my lord.
Kha.
Oh, yes, my lord. Peter, Pata number 22, Yes, my lord. 26/6/68 নং হুকুম,
Assamese, sir.
my lord, হুকুম মতে 52 নং দাগত সমুদয় জমি ফৰিদা সূত্ৰে পট্টাদাৰৰ সিদ্ধাৰ্থ কলিতাৰ স্থলত ইন্নচালীৰ নামত নামজাৰি হৈ পট্টা নম্বৰ 27 পট্টাত নাম চামিল হয়। My lord, next go my lord, চিটাৰ 23/6/69 my lord হুকুম মতে 52 নং দগা চয়াংশু লেচা মাটি পট্টাদাৰৰ লগত শ্ৰী ৰহমান শেখৰ নামত নামজাৰি হৈ 27 পট্টাত চামিল হয়। পট্টা has been changed my lord. My lord, next my lord, last para my lord, remarks column, শ্রী পন্নধর বরা ডেটেড চয়াংশু my lord, রহমান শেখ পিতা তৈয়ব আলী নাম সংশোধন করি আব্দুর রহমান পিতা তৈয়ব আলী, that is my father my lord, আব্দুর রহমান কৰা হল। কোনদৰে চোৱা হল, সংবিধানৰ সংশোধনীৰ বাবে অনুমোদন দিয়া হল my lord. Subsequently my lord, after the death of my father's, our brothers and name sisters name my lord is incorporated in the rights of land record my lord. My lord, page 119 my lord. Same patta my lord, hukumote 52. My lord, these documents was not proved before the learned tribunal, even not an
Even though it is the order of 2004.
Yes, my lord, 2004, subsequently, my lord. Obviously, my lord, after the death of my father, it will be inherited.
Where you have stated that your father had land property in your
Yes, my
written
lord.
statement,
Yes, my lord, in the additional affidavit, my lord,
in the written statement,
my lord. Regarding the land, my lord, in the written statement, I have not mentioned, since my lord document was not furnished to me, my lord, it was subsequently came to me, my lord. For other explanation regarding, my lord, the discrepancies of my father's, my lord, all these things I have clearly explained in the written statement, my lord, as well as evidence in sieve,
now if you have received any such documents,
my lord.
the duty of the petitioner
Yes, my lord.
just a minute.
My lord. My lord, death certificate was proved before the tribunal. My father's death certificate.
Yes,
My-
please proceed with your written statement.
Yes, ma'am. My lord, in the written statement, page 19, my lord, paragraph 6, my lord,
Kindly read.
my lord, I have annexed the death certificate of my
Mhm.
father, which is proved before the tribunal by calling the government officials, my lord, register
Mm.
birth, date and births, my lord.
Mm.
That is proof, my lord.
There is no denial of the fact
Yes, my lord.
that one Abdul Rahman
Yes, my lord.
expired.
Yes, my lord.
That's there.
My lord, thereafter, I have annexed the school certificate, next page, page number 20.
Mm.
My lord, wherein the petitioner, my lord, my lord, date of birth is mentioned. The school certificate, my lord, is page annex page number 45 in my petition, my lord, which is also proved by calling the headmaster, my lord.
Mm.
Yes, my lord. My lord, thereafter, my lord, I have annexed the voter list of 1966 and 1970, page number 21, my lord.
Mm.
My lord, the certified copy before the tribunal. And thereafter, 79, my lord. 79 onwards, my lord, till date, my lord, my father's name written as Abdul Rahman, R. Rahman, my lord. And my grandfather's name also written correctly, my lord, Toyob Ali. And my brothers and sisters' name also incorporated, my lord, along with my petitioner's name. There is no dispute, my lord. Till date. And village is, my lord, 1966 to till date, my lord. Village is same, Thana is same, my DS is same, my lord. Everything is same, my lord. Only name is Abdul Rahman Ali and Abdul Rahman and Abdul Rahman, my lord, is there is. And that is, my lord, I have established even before your lordships by filing the land documents showing my elder uncle, my lord, Innos Ali, whose name is appeared in the voter list of 1966, my lord. Thereafter, my lord, I have explained, my lord, regarding the discrepancies in page number 23, my lord, paragraph 14.
Mm.
There is also explained, my lord, regarding the discrepancy, some age, my lord. This is the approximate as it is written by the government, my lord. My lord, here is I have written regarding the root name of my father. Rahman is everywhere, my lord. No dispute, my lord, in the Rahman, my lord. My lord, in the written statement, I have not fairly submitting, my lord. I have not stated about my land documents, my lord. These facts was not brought to the learned councils, my lord, before the learned tribunal. Subsequently, my lord, before your lordships, I have brought my lord. My lord, the DW2, my lord, petitioner deposed as DW1, and his own brother Kader Ali, my lord. He was the DW2, my lord. He was cross-examined by the tribunal, but no any question was put by the tribunal, my lord, regarding the discrepancies of my father or father of the DW2, Abdul Rahman, my lord. And my lord, DW3, some one uncle, my lord, was deposed before the tribunal, my lord, stating the facts, my lord. The petitioner is the son of Abdul Rahman, my lord, or Abdul Rahman, my lord. Those who are residing since 1966 till date and died on the, my lord, in India, my lord. It's also proved by the government officials, the contents of the death certificate, my lord. My lord, the authority created the reference, my lord, most illegal, your lordship. If it was verified correctly, my lord, or investigated, going through the local residence, my lord, all documents was found by the police, my lord, at that point of time, my lord. My lord, notice was issued to the petitioner, my lord. In the notice, it was itself written, my lord, Nothipatra Nuhuakoi after 25 March 1971, not before, my lord, not prior, my lord, after 1971, my lord, all documents, my lord, no discrepancies, my lord, corroborated, my lord, lordship. Only one part, my lord, 66 and 70, my father's name, my lord, and also my grandfather's name, Toyum, my lord, Toimur. This one.
Anything else?
My lord. My lord, due to the mistakes, my lord, incorporated by the government officials, my lord, or the respondents, my lord. My lord, in page number 29, my lord, I have stated very much, my lord, your lordship. Page number 66 voter list, my lord. I have collected the certified copy, my lord, in the A's part, my lord. Although it is written column number 6, Anumanik Boyok, my lord, this approximate as, but my lord, the department authority, my lord, inadvertently also, my lord, written age of my father 74 years, whereas it is, my lord, page number 32, it is clearly written in the extract copy, my lord, it is 26, my lord. So this kind of, due to this kind of mistakes, my lord, the petitioners is suffered, my lord. The lordship page 32, my petition, my lord. Last part, my lord, my father's name is there. My lord, here age is 25, clearly written, my lord, but in the certified copy, it is written 74 years. So, my lord, this kind of silly mistake, my lord, petitioner has no any hand, my lord.
Anything else?
This much, my lord.
Want to rely on any judgments?
My lord, today, my lord, I have not brought judgments, my lord, regarding the discrepancies, my lord, or the evidences, which is not shaken by the, my lord, state prosecution. I have not brought, my lord. If lordship permits me, I will provide tomorrow, my lord. My lord, actually, I got not clearly submitting. I did not time, my lord. Yesterday, due to my father-in-law's some religious ceremony, my lord.
Okay.
That's why, my lord. I could not brought, my lord, the judgments, my lord.
Mr. Payeng, the tribunal found that the petitioner is the son of one Abdul Rahman. There is no doubt about it.
Yes.
But existence of Abdul Rahman
prior to 1971.
prior to 1970
That is the only point.
has not been proved by the prosecutor.
Prosecutor.
My lord. But then as per notice, my lord, after 71.
That's
So, what do you have to say here?
well, first of all, your lordship will find it's 66 footer list, my lord, page 29.
That is exhibit 1.
Yes. Page 29, my lord.
Hmm.
Here, the footers are, my lord, Inna Salik.
Hmm.
Father name is Tom.
Hmm.
Is it about 34 years? Then Rahman Ali, Tom. It is age is 74 years. And Toripon Nessa, relationship column, Innas means she was the wife of Innas, is it about 39 years. These are the voters murdered in 1966. Then your lordship may kindly see 1970 also. It's corroborated the same manner. 1970 voter list in Darwajan village, it is Innas Ali, Tom, Rahman Ali, Tom, Soripon Nessa, Innas. Now, as per my learned friend, this Rahman Ali is his father.
Hmm.
And in 1966, the age was wrongly written, but in 1970, it is correctly written as 29 years. And the entire case, my lord, I have gone through whatever, my lord. In entire case, he is trying to establish this Rahman Ali as his father, but there is no evidence to that effect. That this Rahman Ali, son of Tom of 1970, is his father. Now, to differentiate, my lord, we may compare the because 1979 is not a, my lord, it is not a, my lord, certified copy. So we may compare the voter list of 1985, my lord, whom the petitioner is claiming to be father of the father. 85 page 39, my lord. Here it is.
Hmm.
89 page 39, my lord. Yes, 89 page 39. Here it is from A. Rahman.
R. Rahman.
R. Rahman, son of Toyob Ali, aged about 40 years, and Ahatan Nessa, wife of Rahman, aged about 30 years, are enlisted as footer. Now, can we, the petitioner could not establish or produce any documents or any evidence that this R. Rahman of 1985 and the Rahman Ali of
66 and
1966 and 70 is the same in one point. And in fact, I will submit one thing, my lord. Except the village name, all others are different. My learned friend is saying that only, my lord, there are some spelling mistakes and some name differences. In fact, everything is different except the village name, my lord. Village name is Larwajan, it is admitted. Had this, my lord, voter of 1966 and 70, suppose Inna Sali and Saripon Nessa were there.
Inna Sali.
Yes, Inna Sali and Saripon Nessa were there in the voter list of 1985, along with this A. Rahman, that we could understood that, my lord, they may be of the same family, or the Rahman Ali and A. Rahman is the same person. But this Inna Sali and Saripon Nessa is missing after 70. And Rahman Ali has become A. Rahman. The Tom has become Toyeb Ali. Everything is different. Claiming that, my lord, that A. Rahman and Rahman Ali is same person will not do. that has to establish by some evidence, whatever manner. In fact, if your lordship may kindly see 93 voter list, page 41. If we accept that the 26, he was 26 years in 1970, the age is also contradict. 1970, if we accept that 1970 he was 29 years, his date of birth will be sometime in 1941, my lord. There are some discrepancies in age also, 3-4 years. But the name is clearly different, my lord. Abdul Rahman and Rahman Ali. Now, what evidences he has given to that effect? Only statement that in fact he has not positively said. In fact, he has, in evidence he has stated, this written evidence, evidence on affidavit, page 67, para 14, page 72. He has stated, it is further stated in that, stated in the voter list of 1966 as well as in 1970, my father's name recorded as Rahman Ali, but true and correct name of my father is Abdul Rahman, was commonly known as by his root name Rahman in locality, which is found in all the voter list as well as my school city. So, my lord, we have to remember, my lord, the entire contention here, whether the petitioner's father was there prior to 1971. And interestingly, my lord, prior to 1971, 66 and 70 voter list, there is no contradiction. There is clear findings that one, my lord, Rahman Ali, son of Toub, even father name is also not, my lord, different. Toub was present. Only names are coming, my lord, the only differences are arising after 71. That is the point, my lord. Why this voter list of 1985, 93, even 97, even 79, whatever line, though it is not, my lord, not the certified copy, even 79 also, my lord, the name is different. Contradiction started only after 71. Apart from this statement, there is no statement that this, my lord, this apart from page 72, para 14 statement, there is no, my lord, evidence to show that the Rahman Ali, son of Toub of 1966, 70 and 70, and this Rahman or Abdul Rahman after 1971 is the same and one person. This is the only statement to the effect that it was wrongly recorded. It was recorded Rahman Ali, but true and correct name is Abdul Rahman. And in para 3, my lord, in para 5, page 68, he has clearly said that I was born out of wedlock of late Abdul Rahman alias Abdul Rahman and Ahatun Nisa on 1/9/1986. He has not said, my lord, Rahman Ali is son of Rahman Ali here.
Nowhere stated.
Nowhere stated. Only, my lord, statement is that in para 14, page 72 in evidence, it is that it is further stated in the voter list of 1966 as well as 1970. My father's name was recorded as Rahman Ali, but true and correct name is of my father is Abdul Rahman. Here it is stated, but he has not, my lord,
It
there
is
is
any evidence to that effect.
any evidence to that effect. Even, my lord, the other witnesses evidence also, the DW2, the project brother of the petitioner, Kader Ali, he has also not stated that. He is also in para 5 said that It is further stated in voter list of 1966 as well as in 1970. As exhibited by the proceeding, my father's name was recorded as Rahman Ali, but the correct name of my father is Abdul Rahman, who was commonly known by his root name Rahman in my locality, which is found in all voter lists as well as in documents. It is further stated that the subsequent voter list and in the documents exhibited by proceeding, my father's name sometimes shown as Abdul Rahman, A. Rahman, Abdul Rahman, who is same in one person, an identical person. Here it is said, my lord, he has not said that Rahman Ali and Abdul Rahman is same in one person. He has said, my lord, it is further stated that in the subsequent voter list of other documents exhibited proceeding, my father's name shown as Abdul Rahman, A. Rahman, and Abdul Rahman, who is the same in one person, one and identical person. This statement is there with regard to A. Rahman, Abdul Rahman, and Abdul Rahman, not with regard to the Rahman Ali. Rahman Ali, as per them, it's recorded in 1966 and 70. Why it was recorded, it is not said. But whether it is wrongly recorded or, my lord, only statement is that it was recorded in 1966 and 70 as Rahman Ali. But correct name is Abdul Rahman. This is the only statement with regard to the father by the DW2. Others also, my lord, nobody has said that Abdul Rahman and this Rahman Ali is same in one person. He has brought 4-5 witnesses to prove his case, my lord. The Gangura has also not said anything about that Abdul Rahman and Rahman Ali is same in one person. So the tribunal has rightly said, my lord, tribunal's opinion, it is clearly said. Proceeding could not clearly said, my lord. The proceeding could not link to any of the person of the voter list of 1966 and 70. Either Innas Ali or Rahman Ali or Sharifun Nisa by any means of evidence. Gangura's evidence also, he has not stated about Rahman Ali. He has stated only about Abdul Rahman. And the headmaster also has not said anything about this Rahman Ali. And my learned friend has brought some documents before this honorable court which cannot be accepted at this stage. However, my lord, even though we accept this document, the Jamabandi copy, it is not that he was not aware of this document, because this document, his name was mutated just some days before the, my lord, passing of this opinion. Because the mutation was done on 9/11/2022. And this opinion was passed on only just after 1 month from that. 22/12/2022. And there is no statement with regard to the land documents in the WS, neither in the evidence. And interestingly, my lord, if we go 116, page 116, There it is, my lord, your lordship will find the correction of name from Rahman Sheikh to Abdul Rahman was made after about 50 years. The Go, my lord, says, as per order dated 23/06/69, the name of Sri Rahman Sheikh has been included against DAC number 52, land measuring 2 bigha, 3 kotha, 2 lesa, with patta number 27. And this was done on 3/9/1969. Then next, my lord, note, Latmondol Sri Punyeswar Bora dated 2022/08/04. The name Rahman Sheikh, son of Tayyab Ali, my lord, the father name is Tayyab Ali here, has been corrected as Abdul Rahman, son of Tayyab Ali. Since the report of Latmondol, correction was approved, circle officer Sri Orup Vikramala, and this was corrected on 4/8/2022. Earlier in 69, some Abdul Sheikh was there. Rahman Sheikh was included. And this is corrected only in 2022 during the pendency of this pendency of the my lord tribunal, the proceeding. Then my lord, the proceeding applied for my lord mutation. Then it is mutated on 9/11/2022. So, and this was not before the tribunal. It is not that he didn't know anything about this. He knew it, my lord. It was on his application, the mutation was done on 9/11/22. So now they are bringing these documents before the tribunal. Even though we accept that, my lord, this cannot be accepted, this cannot be a ground for granting him citizenship. And we cannot see this Rahman Sheikh. In 69, it was Rahman Sheikh. One Rahman Sheikh was included in that. And that Rahman Sheikh has been corrected after about 69, about 50 years as Rahman Abdul Rahman. So this cannot be accepted as a matter of evidence for the purpose of citizenship, at least. Others, my lord, discrepancies, my learned friend is saying, my lord, the discrepancies are not created by him. It is by the state authority. They have prepared the voter list. That is not that cannot be the ground of, my lord, ground, because it is their documents. They have produced this document as evidence. If it has to be accepted as a piece of evidence, it has to be accepted as in whole, my lord. Not only that part which are helpful for them, that may be accepted, and which are not helpful for them, that should not be accepted. That cannot be the, my lord, submission. So if the documents, voter list, they want to rely on those voter lists, they have to rely it fully. If they don't want to rely it, they have to, my lord, they should not reject, rely it. They cannot rely it partly. If they want to, my lord, rely, they may rely it fully. Judgments are there, my lord, that effect, the voter list.
Is Mr. Ali. Mr. Kuli. Do you have a copy of the writ petition?
No, my lord.
Mr. Payeng,
My lord.
tell us one thing. Sometimes we see electronic voter list,
Yes,
and these voter list of 2005, 2010, 93. That was adduced by the petitioner before the tribunal. These are not in the electronic form.
yes. These are hard copy. In the normal
No,
certified.
there is a reason behind. In a voter list in electronic form, you have all the details. Just compare page 41 and 49.
Okay, yes.
Page 41 and 49. You saw the district. You have seen the district,
Yes. Ila Kamrup.
then police station on one hand, subdivision, then Moja, then village.
Village.
These are missing in 2005, the
Yes.
list at page 49. 2010 voter list at page 51.
Yes,
Will you able to tell us the reason?
2013, my lord. Onwards, my lord.
You have 2013 voter list,
Yes, my lord.
which page?
My lord, page number, my lord, 58, my lord. 58, lordships, certified copy, my lord.
Here also it is missing.
Yes, my lord. 2019, my lord, also. Page number 60, my
How
lord.
can this thing can missed?
Yeah. The- Right. Okay.
Yes, Mr. Pang, you want to
Yes, my lord,
add anything?
yes, in this case, my lord, the only contention is that, my lord, one Tahajuddin, who is claiming to be, to be the son of, my lord, Rahman Ali of 1966, that aspect is not established. Because a person, my lord, picking up a documents of 1966 and 71 voter list and claiming that he is my father, that aspect has to be established, my lord. That I have relied yesterday, my lord, one judgment of this honorable court, when it is said, my lord, Tahajuddin, my lord, Aziz Mia, WPC number 2370 of 2023, my lord.
2370.
Yes, 2370 of 2023. They are in para 14, my lord, it is clearly said. Claiming somebody as, my lord, the father itself will not do.
Oh, that means the Sigdar's case.
Yes, yes. No, not serious. There it is said, para 14, my lord.
Hmm.
We are constrained to observe that mere claim by a suspected person by referring to a voter list, claiming a person therein to be his father, is not conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim will have to be substantiated with further materials accepted in law. So here it is claiming that this Rahman Ali is his father, whose name is there in the voter list of 1966 and 70. This Rahman Ali has become a Rahman later on. So he could not establish that this Rahman Ali is his father, and that Rahman Ali and Abdul Rahman is same in one person. By any means, my lord, by any evidence, by bringing any evidence to that effect. That is the only point, my. Otherwise, it can be accepted that one Abdul Rahman is his father, but he could not establish that this Rahman Ali, who is there in 1966 and 70, is his father. And there is no evidence to that. That must be. And discrepancies in the voter list, my lord, there are judgment of that also, that it is not creation by the, it is not a creation by the petitioners. I'll submit that judgment. I'll just that's all. I'll give the judgment. That's all, my lord. I'll just give the, my lord, letter. That's up. I'm giving.
May I please, Your Honor?
Yes.
May I please, Your Honor? My lord, I want to give some answers, my lord, the questions put by my learned friend. My learned friend said, my lord, regarding the age, my lord. Regarding the age in 1970, my lord, your lordships, my lord, kindly page 37. My lord, page 37, 70, my lord, voter list, page 34, my lordship. My lordship, there are 4-5 years discrepancies in age, my learned friend said, my lord. But my lord, in the voter list below part, my lord, in column part, my lord, note, my lord, note part, Column number 6, my lord, it is clearly written in 1/1/1970, sonor, anumanik boyok, my lord. It is approximate in everywhere in the voter list, my lord. This answer, my lord, given by my learned friend itself, my lord. So discrepancies in age, my lord, 4 years, 5 years, 10 years, maybe 20 years, my lord. It is anumanik. The word approximate, my lord, it is doubtful word, my lord. So it is not, it may not be accepted, my lord. My lord, further, my learned friend said that 1970 voter list is a extracted copy I could not produce before the certified copy before the learned tribunal, my lord. But this extracted copy, my lord, whether, my lord, my learned friend can deny it, my lord, this is not created by the government, my lord. They can't, my lord. This is the exact original copy, my lord. No doubt it is, we have not collected the certified copy, my lord, and not submitted before lordships as well as learned tribunal. But this is the main original copy, my lord. This may be verified, your lordships, by through the government
How
official.
can it be by the court? Only by
lord.
the tribunal.
Yes, my lord.
Particular
But
case before the
tribunal,
Tribunal.
yes, my lord. Further, my lord, the tribunal cannot go beyond the notice, my lord. Here in the Finance Tribunal matters, my lord, FT cases, my lord, notice is number 1, my lord. My lord, notice was issued to the petitioner, my lord, to prove his citizenship after 25/1971, my lord. And after 25/1971, petitioner, my lord, successfully produced and proved all the documents, my lord. 79 onwards, my lord, petitioner's father's name and, my lord, voter lists, my lord, are okay, my lord. Only dispute, my lord, discrepancies are 66 and 71, 70, my lord, Abdul Rahman Ali, my lord. And petitioner clearly, my lord, raised the point, my lord, before the learned tribunal in the written statement as well as evidence, my lord. But the learned tribunal failed to put any question, my lord, on this disputed fact, my lord. Cross, my lord, generally, my lord, cross has been done, my lord, on disputed questions of facts, my lord. The meaning of cross, my lord, this is the meaning of cross, my lord. Cross examination, my lord. Nowhere, my lord, never, my lord, the tribunal put any questions over these facts, my lord. That's why, my lord, I may submit, my lord, the petitioner successfully, my lord, establish his case before the tribunal. And his evidences, my lord, not shaken by the state of prosecution side, my lord, page number 1111, last part of the judgment, my lord, 1110. Here the tribunal found held, my lord, the proceeding could not establish his link with his projected parents, namely Abdul Rahman and Ahaton Nessa, by voter list 2005, 2010, 2013, and 2019. My lord, here it is said, could established, my lord. Well, partly said, I am established. And, my lord, further, my lord, it is said, the proceedee or his parents, the proceedee part is okay, or his parents could not produce any documents to establish that they are living. How, my lord, his parents can produce before the tribunal whether they have already died, my lord? So, my lord, mistakes is everywhere, my lord, even on the part of the petitioners, in the written statement, writing, my lord, on the authority, my lord. Tribunal itself, my lord, said, and clearly said, here it is wrongly written, my lord, by the tribunal, my lord, I may submit, my lord, from India, living in Assam, India, from or prior, my lord, where from prior, my lord, has come, my lord. Notice not said that, my lord. Notice never says, I have the original notice, my lord, which was duly received by the petitioner. It is, my lord, written after. After. So, no, there is no any question prior to 1971, my lord. How petitioner will, my lord, establish prior to 71? Tribunal may not go, my lord, beyond the record, my lord.
My learned friend is committing a mistake in that part, my lord. It is the duty of the petitioner to establish that
Yes.
he is residing prior to state of Assam, prior to 1971. Then only, my lord, he can do this. If he can establish that he was residing or his parents were residing prior to 71, then only
No.
his citizenship can be considered.
Notice,
Otherwise, if he can establish that he is here in Assam after 71, then he is to be taken as foreigner.
notice doesn't say that.
Notice means notice here. In notice, it is given that you are coming after 25/3/1971. So you are a foreigner. So you have to establish that you are not coming after 25/3/71. You are coming prior to that.
Further, my lord, I may submit, my lord, regarding voter ID, my lord, voter identity card. My lord, voter identity card duly issued by the government, my lord, in the name of the petitioner. Voter identity card, my lord, is a vital document, my lord. It cannot issue to the any foreigners, my lord, foreigner citizen, my lord.
So voter identity card, if any PIC is there, so you are the citizen of India.
My lord, to some extent it is proved, my lord. Some extent it is proved. I am not absolutely, my lord. Say it, my lord. And my lord, in the voter list, all the voter list, my lord, after 2005, 90, my lord, 10, 19, my lord, against my name, my father's name is written R. Rahman, and all my brothers and sisters, my other family members, it is written Abdul Rahman. Only the petitioner's, against the petitioner's name, his father name is written R. Rahman, my lord, A. Rahman, my lord. It may be Abdul or Abdul, my lord, but A. Rahman. My lord, difference, my learned friend said difference in village is okay since 1966. Only difference there is found difference, my lord, in Mosa, my lord, and others, my lord. My lord, it is not done by the petitioner. Never, my lord. It is duty of the government, my lord. Recently, my lord, government done, my lord, changes, my lord, constituency, my lord. So, my lord, my humble submission, my lord, lordships, may declare the petitioner as Indian citizen, my lord. And he has successfully, my lord, established his citizenship before lordship, as well as the tribunal.
My lord, I just refer this judgment as this is, my lord, 2000 WPC 1002 of 2016, my lord. This is with regard to the, my lord, creation of the voter list. It is not the 1002 of 2016. This is Kasiran Bibi, my lord. There in para 30, my lord, last page number 8, internal page 8.
Can read it.
Yes. My lord, here it is said, reliance placed in the case of Abdul Matlab versus so can be no assistance to the petitioner in as much as it is already been clarified by this court in previous decisions that the state decision did not lay down any law and was a decision confined to the facts and circumstances of the case. Regarding discrepancies in the voter list, which the petitioner contended were not her creation, being entered into by officials of election commission and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter list were adduced as evidence by the petitioner herself to prove her case that she was not foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voter list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. So voter list, creation of voter list by the government cannot be excused for the proceeding. So this is clear from this judgment. Another issue, my lord, my learned friend was asking, saying, my lord, that a photocopy of 1979 voter list. This is, my lord, another judgment of this honorable court. It is said photocopy, in fact, photocopy cannot be accepted as a piece of evidence. That a part in this, with regard to, my lord, foreigners case also, the issue has been settled. Yeah, this is, my lord, WPC 6090 of 2016.
Yes.
6090 of 2016. WP, my lord, Abdul Majid. There in para 17, it is clearly stated. Exhibit 6 is a photocopy of electoral roll of Abhayapuri South constituency of 2014, where the name of the voter is Abdul Majid, son of so-and-so, as a about so-and-so. If Abdul Majid was 30 years of age in 2014, it would mean that he was born sometime in 1984, which is contrary to the date of birth mentioned in the school certificate. That apart, the photocopy cannot be treated as a valid piece of evidence. There is no certification at the bottom of the document that it was a certified copy of the original to be treated as a certified copy and thereby a secondary piece of evidence. Therefore, document would not be of no assistance to the petition. So photocopy cannot be taken as a secondary piece of evidence also. And another, as my learned friend has argued, one point, this is with judgment with regard to the photo identity card. It is in so far exhibit 7, I'm giving the, this is my lord WPC 3547 of 2016. 3547 of 2016. Here, my lord, this is Babul Islam, the party names. There in para 20.2, it is said, my lord, 20.2, it is said. In so far as exhibit 7, electoral photo identity card is concerned, besides not being proved, it is a post-25/3/1971 document. Besides, merely producing such an identity card in absence of supporting evidence would not be a proof of citizenship. So this is with regard to that one. Then one more judgment on the matter of rebuttal, as we have not questioned, cross-examined them or cross-examine on that fact, my lord. It is the duty of the petitioner to prove their case by bringing, my lord, cogent, reliable, and admissible evidence. If they can bring this cogent, reliable, and admissible evidence, then we may cross-examine or we may, my lord, go for rebuttal. That is settled, my lord. That is because that is settled in WPC 2641 2017, my lord. 2641 2017. State of Assam versus Ohabali. They are in para 16. In that case, para 16, it is the full bench of this court has been relied on, the state of Assam versus Muslim Mandal. And they said, my lord, under section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner, but a citizen of India, and this burden never shifts. The burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the fact in issue. By mere filing of documents without examining its admissibility and without documents being proved or without examining the relevance, it cannot be said that the proceedee had discharged the burden. Question of rebuttal of evidence by the state will arise only if the proceedee adduces evidence which are admissible, proof, and which have relevance. So if they can bring admissible evidence and if it is proved and which has relevance, then only the rebuttal will come. We may not go for rebuttal. So this is enough, madam.
Yes.
Yes.
Mr. Sek, you said regarding the notice.
My lord.
What is your objection to the notice?
My lord, notice was issued, in notice, my lord, the petitioner would have to prove, my lord, after 1971, my lord, 25 March 1970. This is This is
After 1970.
my
Yes.
lord.
How you are affected?
My lord. Yes, my lord. After 1971, my lord, the
Why the
documents,
reference is well? Why the decision of the tribunal is there?
no notice itself, my lord. In the notice it is written, my
Hmm.
lord.
What is it?
My lord, I have not annexed the notice, my lord. It may be in record, my lord, LCR, my lord.
Do you have a copy of the notice with you?
Yes, my lord.
Kindly read the notice.
My lord, it is in Assamese, my lord. যেহেতুকে ক্ষমতাপন্ন কর্তৃপক্ষের দ্বারা আপনার বিরুদ্ধে এনে এক প্রসঙ্গ বা অভিযোগ উত্থাপিত হৈছে যে আপুনি কোনো বৈধ নথিপত্ৰ নোহোৱাকৈ 25 মাৰ্চৰ পিছত 1971 পিছত অব্লিক মাই লৰ্ড 1 জানুৱাৰী 1966 আৰু 24 মাৰ্চ এই সময়ছোৱাৰ ভিতৰত অবৈধভাৱে অসমত প্ৰৱেশ কৰিছে মাই লৰ্ড।
So you have entered into territory of Assam
Yes, my lord.
after 25/03/1971
My lord.
without any valid document.
Right.
That was the notice issued to you.
Yes, my lord.
So how you have proved that? The evidence that you have, that is the proof that you continued to be here since that time of your father,
My lord.
right?
Yes.
So how you have
My lord, in
agreed
this, my
like
lord,
this?
yes, my lord. In this, my lord, petitioner, my lord, relied 66, my lord, though there is name
True.
discrepancy.
So-
Yes, my lord. Name discrepancies in his father. That
How
is,
come the tribunal exceeded jurisdiction in determining the issue?
my lord.
Why you have said so?
My lord. In page number 111, my lord, last page, my lord.
Hmm.
There it is written prior to 1971, my lord. I just, my lord, point out this one.
Yes,
Yes, ma'am.
first paragraph.
Last, yes, ma'am. One, yes, ma'am.
Hmm.
First paragraph, my lord.
Prior to 24/03/1971.
My lord.
Yes. Cutoff date is 24 midnight. Starts from 25.
My lord.
And the reference was, the notice was.
Yes.
That you have entered on or after 25/03/1971.
My lord.
So anything else, Mr. SK?
My lord, this much, my lord, I will provide some judgment tomorrow, my lord.
No problem.
Yes. Obliged, my lord.
Hard deadline. Place tomorrow on the prayer of the petition. Enabling him to place the 11 in support of his application. Step করে লাগাই দিন অ্যাডমিশনের একেবারে আর ইনপারফেক্ট
Obliged, my lord. Obliged, my lord.
May I please, Your Lordship? Well, before proceeding with this case, Lordship, there is an order of this honorable court, Lordship, to obtain an opinion regarding whether a lady can give birth to a child of 62 years old. In that effect, Lordship, we submitted an application before the superintendent of GMC, Lordship. But they have returned the application saying that the person concerned will require. That lady is no more. She expired in the year 1997. Mother of the petitioner. that I can give that application and the opinion of the lordship and the written of the doctor's lordship. From the record, lordship, it appears that when the petitioner's mother was 62 years old, she gave birth. Who is the petitioner, lordship? Fact, lordship, the petitioner is declared as foreigner by the imperial order, that is page 59.
Mr. Pang,
Um,
there's a judgment in this regarding the birth certificate. Our state rules is also very clear. Page number 16.
Date of registration 24/1990.
Date of registration 20/04/1991.
Yes.
And when it was issued?
Issued on 30/3/2006.
20/03/2006. As per the record.
Yes.
Whether a birth certificate can be issued
In fact, lordship,
after 15 years.
Procedure is established, now. Procedure is here. How to get the related birth certificate.
in fact, registration was done on 24/1991. Authority was examined before the tribunal, but they failed to
Is in the record.
produce the record because they are saying that there was a fire, lordship, burned by the fire, and all the records has been destroyed.
Fire ticket.
You are supposed to establish it,
Yes, lordship, absolutely.
right?
Failed, lordship, because of that reason. We have summoned the authorities through the learned tribunal, lordship. Once they have stated say so, lordship, there was no option of the petitioner, lordship.
Have you brought anyone with the counterfoil?
My lord, so for other record, lordship, that we have,
Mr. Khan,
My
you
lord.
are aware of all these birth certificates, right?
my lord,
Can there be a serial number without the book number in a particular issue, particular certificate? The original that you have placed before the tribunal is without any book number. And that is why the records
serial number
got
is
burned.
there.
Serial number is always there. Everywhere you will get. Which is the book number.
You know, the authority has not disputed that this is not the,
Question of issue is not that. The rule is very clear. Rule frame under this Registration of Birth and Death Act. Very, very clear within how much time it has to be issued. And this was issued on 28th of March 2006. You are aware, our High Court has spelled down the law very well.
Well, regarding the registration is concerned, the registration was done in due time.
That is not the issue, Mr.
But so far the document is concerned obtained by the petitioner and issued by the authority. That is subject. It is not a case that the registration was done after 10 years or 15 years. Registration was done in due time. His date of birth is 15/4 and registration was made after 5 days. While page 17 is the school certificate, which also supported the same date of birth.
Hmm.
15/4/1991.
Okay,
From
let us see your written statement.
my lord. My written statement, lordship, is page 33. We have also filed on additional written statement. Page 33 in my written statement.
Yes, Mr. Can read your WS?
My lord. Yes, 33.
Please read.
The
Yes,
proceed,
33.
the proceedings name Mohammad Manal Haq, son of late Sikim Ali, father and late Alexander Bibi mother, born on 15/4/1991 in his native village Sirakwa, Kutighat, Patangitola. Post office so P.S. Mankasa in the district of Dhubri, now South Samarasa. However, the proceeding is residing permanently in the same village, opposite village. The father of the proceeding died in the year of 1993 and subsequently his mother also died in the year of 1997. The proceeding read up to class 7 from Dharakopa ME School in the district of South Salmora, Mankasa. The proceeding being hailed from poor family, he could not proceed further and further study. And since his childhood, he is a daily wage earner and at such sometime he came to Guwahati to work as daily wage labor for his livelihood. The proceeding being born on 15/4/1991 and accordingly his name has been registered on 24/1991 by registration number by register of birth and death Wazari Kandi PhD, as well as in his school transfer certificate issued by the headmaster so and so ME school. The family structure of the proceeding is given so and so. The parents of the proceeding being citizen of India and as such their names have been recorded in the electoral roll of 1960 as Sikim Ali, son of Sabed Ali, and Alexander Bibi, wife of Sikim Ali, under Mankasar Legislative Assembly constituency Assam at serial number 12, house number 12, showing the name of village Sirakwa. Post office Jhaudanga, P.S. Mankasar in the district of Gwalpara. Well, at that time the district was Gwalpara. The name of parents of the proceeding has been recorded in the electoral roll of 1966 as Sikim Ali, son of Sabed Ali, and Alexander Bibi, mother under 31 Mankasar Legislative Assembly constituency Assam at serial number so and so, house number so and so, showing the name of village Sirakwa, Kutighat, post office Kalapani, P.S. Mankasar in the district of Gwalpara, Assam. in the electoral roll of 1970, the name of his parents has also been recorded as Shikim Ali, son of Sabed Ali and Alexander Bibi, wife of Shikim Ali. Shikim under 31 number Mankasar Legislative Assembly Constituency, Assam at serial number 12, showing the name of village Siriakwa Putighat, post office Kalapani, PS Mankasar in Dadan district of Golkar. The parent of the Pursidi being citizen of India, and accordingly their names have been recorded in the electoral roll of 1977 as Shikim Ali, son of Sabot, and Alexander Bibi, wife of Shikim Ali, and under 21 number Mankasar Legislative Assembly Constituency, Assam, at serial number 12 and house number 12, showing the name of village Siriakwa Putighat, post office Kalapani, PS Mankasar in the district of Golkar, Assam. The Pursidi being citizen of India, and accordingly his name is recorded in the electoral roll of 2017 as Monal Haq, son of Sikkim Uddin, under 21 number Mankasar Legislative Assembly Constituency, Assam, at serial number 12, at village Siriakwa Tupar. It is pertinent to mention here that the name of the father of the Pursidi has been recorded as Sikkim Uddin in electoral roll of 1917 and in the birth certificate of the Pursidi instead of Shikim Ali. Both the name Shikim Uddin and Shikim Ali indicate the name of same person with one identity, that is the father of the Pursidi. However, in his school certificate, the name of his father has been recorded correctly. That in view of the above, it is demonstrated that the Pursidi is the son of Shikim Ali and grandson of late Sabed Ali, whose name have been recorded in the electoral roll of 1960, 66, 70, 77, and as such, the Pursidi is an Indian national by birth, and there is no doubt about the Indian citizenship of the Pursidi. Hence, the instant Pursidi may be dropped for the end of that. All these documents initially Xerox copies were given, subsequently original documents were submitted. Affidavit. Page 39 is my additional written statement, whereby one land documents have been lost with exhibited. It is the final copy.
Yes, that land document.
My lord, page 31 is the land document.
Hmm.
This is the Kotian.
Hmm.
Serial number 1, Shikim Ali Sheikh,
Hmm.
Pita Sabed Ali Bepari,
Hmm.
Siriakwa. My lord, in serial number 2, your lordship will find Bahazan Bibi, Sami Shikim Ali is given. My lord, this is Bahazan Bibi is not, was not my mother, lord. Perhaps the name of Shikim Ali has been wrongly reflected. In fact, she was the co-patadar.
Hmm.
And this land document, that is page 32, your lordship will find 9/3/1961,
Hmm.
containing the name of the petitioner father. And lordship, all documents, lordship, that we have submitted are relating to lordship, my father, mother, and grandfather. And one lordship PW2, my cousin brother was examined. That is page 49.
Hmm.
And he was also cross-examined by the tribunal. Those evidence, lordship, were also ignored by the tribunal. Page 49. And my evidence, lordship, that is page 43 is DW1, that is my evidence. And 49 is the evidence of DW2, my cousin brother. Okay. Page 49.
Yes.
Serial number one, Lordship. I am the cousin brother of the opposite party, namely Muhammad Moinul Haq, alias. My father name is late Iman Ali, and my father name is late Bhendu Bepari. My grandfather Bhendu Bepari and the grandfather of Moinul Haq, late Sobed Ali, are own brothers. We live in the same village, Sirakwa, Putirghat. I know him and his family. We are three brothers and one sister. My uncle name is late Shikim Ali, has 5 children, 3 daughters and 2 sons. That I am an Indian citizen by birth. My name is recorded in the voter list of 1985 to till date under 21 Mankasar LAC Assam, continuing up to date. That my cousin brother, namely Monal Haq, born in the year of 1991, and presently he is about 27 years old. In view of the above, it is established that Monal Haq is the son of late Shikim Ali and late Alexander Bibi, whose name has been recorded in the electoral roll of 1960, 66, 70, and grandson of late Soviet Ali. And accordingly, he is Indian national by birth. And there is no doubt about his citizen, hence the instant proceeding may be dropped for the end of. Now, he was cross-examined, that is page 52. I have come here to adduce evidence for Monal Haq. He is my cousin brother. My father has 4 brothers, namely Zohruddin Sheikh, Iman Ali, Minasuddin, Sohan Ali, Munshi. My grandfather named Bhendu Bepari and Sobed Ali. I have land. Grandfather had land. Hence, my father name is found along with Sobed Ali. Sobed Ali is my grandfather. When I was 21, 22 years old, my father expired. Shikim Ali had 4 brothers. My father's name Shikim Ali. Dawat Ali, Jigir Ali, Muslim Uddin, and Shikim Ali. All of them died. This is not true that Alexander was not the mother of Monal Haq. 22 years back, his mother expired. This is not true that I have given false evidence. But this evidence was not refuted by the state by adducing any document or causing any inquiry also. Not relying that, Lordship, I so far the evidence is concerned, Lordship, I will rely on citation of this honorable court.
You will come back at 2.
My lord, in 2 Lordship, at 2 p.m. Lordship, I have fixed another matter, Lordship. If your Lordship can it be taken up after 3 or any other date, Lordship, no problem. I have already fixed another matter in court number 15, Lordship.
Next week or Wednesday.
Mr. Pang, we do not know the bench, available bench, whether myself with my brother will sit or not.
Yes.
As on date, we do not know. We are not keeping the matter part. On the prayer of the council for the please this matter up.
Obliged.
Switch on the microphone. Microphone.
Yes, my lord. My lord, reference was in the respect of the petitioner, my lord. And the reference was for the period of 1966 and 1971, my lord. The petitioner is in between, my lord, in 1971.
However, the my lord, learned tribunal go beyond the reference, my lord, and declared the petitioner a foreigner of post 1971.
Take your seat. Yes. Which is your link document,
Your link document is school certificate, my lord.
school certificate.
Yes, my lord.
How it is proved?
My lord, proved by the school headmaster, my lord.
Hmm.
It was before the tribunal as DW5, my lord.
Hmm.
This evidence is start from page 63, my lord, of my repetition.
Kindly read.
Lord, Assamese part, my lord. মই উত্তৰ লেংজিবৰী এল পি স্কুলৰ প্ৰধান শিক্ষক মই এই গোচৰৰ অপৰপক্ষ মোচাম্মদ মানিকজান পিতা আব্দুল আলী গাঁও লেংজিবৰী মোৰ স্কুলৰ শিক্ষা গ্ৰহণ কৰা বুলি মই প্ৰমাণপত্ৰ দিছোঁ প্ৰপত্ৰ কে মই দিয়া প্ৰমাণপত্ৰ আৰু প্ৰপত্ৰ K1 মোৰ চহী আৰু বিদ্যালয়ৰ চিলমোহৰ যোৱা 21/7/2018 ইংৰাজী তাৰিখে মই উক্ত প্ৰমাণপত্ৰখন লাহৰী ঘাট BDOই কাউণ্টাৰ চাইন কৰিছে মই আজি মোৰ স্কুলৰ অপৰপক্ষৰ নামত থকা এডমিশ্যন ৰেজিষ্টাৰ আৰু প্ৰমাণপত্ৰ দিয়া কাউণ্টাৰ ফলিঅ'খন লৈ আহিছোঁ আদালতত প্ৰদৰ্শন কৰিবৰ বাবে এডমিশ্যন ৰেজিষ্ট্ৰেশ্যন মতে অপৰপক্ষ মোৰ স্কুলত 1/5/1985 চনত ভৰ্তি হৈছিল মই অপৰপক্ষ 21/7/2018 চনত প্ৰমাণপত্ৰ দিছোঁ উক্ত প্ৰমাণপত্ৰ মই হাতেৰে লিখি দিয়া অপৰপক্ষ মানিকজানৰ ঘৰ মোৰ স্কুলৰ ওচৰত মোৰ মতে অপৰপক্ষ ভাৰতীয় নাগৰিক বিদেশী নহয় মই আদালতক এখন সঁচা প্ৰমাণপত্ৰ দিছোঁ এডমিশ্যন লোৱাৰ সময়ত
অপৰপক্ষই
এডমিশ্যন লোৱাৰ সময়ত স্কুলৰ প্ৰধান শিক্ষক আছিল আজিজুল হক আৰু ইতিমধ্যে তেওঁৰ মৃত্যু হৈছে এডমিশ্যন ৰেজিষ্টাৰ মতে অপৰপক্ষৰ জন্মৰ তাৰিখ 1/5/1979
So as per this, he said that
19
he has issued the certificate,
yes
he
ma'am
has bought the counter folio
yes ma'am
and
admission register
admission
Yes.
register,
Yes.
right?
yes
Okay. Hmm.
to the court মই যিখন এডমিশ্যন ৰেজিষ্টাৰ আজি আদালতত দাখিল কৰিছোঁ সেইখন বহীত কোনো পেজতে পেজ নাম্বাৰ কৰা হোৱা নাই আৰু এডমিশ্যন ৰেজিষ্টাৰখনত মুঠ পৃষ্ঠা সম্পৰ্কে মোৰ উচ্চ পৰ্যায়ৰ বিষয়াৰ দ্বাৰা প্ৰমাণিত কৰোৱা হোৱা নাই মোৰ স্কুলখন এখন চৰকাৰী স্কুল মই যিখন চাৰ্টিফিকেট অপৰপক্ষক দিছোঁ সেইখন স্কুলৰ পেডত দিয়া হোৱা নাই মই 2015 চনৰ পৰা মোৰ স্কুলৰ প্ৰধান শিক্ষক হিচাপে কাম কৰি আছোঁ
So whether this document has been proved,
yes my lord
so this particular evidence adduced by the headmaster of the school
yes
is chosen, reliable and admissible in evidence. Now, it was adduced by the petitioner, or it is the claim of the petitioner that she read up to, she
Yes.
read in this school,
yes
right?
yes ma'am
Now, come to her deposition. The written statement.
my lord is that this is section 35 my lord conduct of
Hmm.
উক্ত বছর
You need not read all.
yes my lord
Read para 4.
ময়রাবাড়ি থানার অন্তর্গত রেঙ্গিগুড়ি গাঁৱত তাইৰ পিতৃৰ নাম আব্দুল আলী আৰু মাতৃৰ নাম মালেকা বানু তেওঁলোক ভাৰতীয় নাগৰিক হয় জবাবকাৰী নম্বৰ 2, 3 আৰু 4 জন্ম গাঁও মহিৰাবাৰীত হয়। এই গোচৰৰ অপৰপক্ষ গোচৰত উল্লেখ কৰা ধৰণে বিদেশী লোক নহয়, তেওঁলোক ভাৰতীয় নাগৰিক হয়। তেওঁলোকৰ ভাৰতীয় নাগৰিকত্বৰ যথেষ্ট প্ৰমাণ পত্ৰ আছে। তেওঁলোক অসম চৰকাৰৰ অধীনত কাম কৰা চৰকাৰী কৰ্মচাৰীয়ে উক্ত প্ৰৱৰ্তনত দিছে। কিছুমান কাৰণত অপৰপক্ষগণে অসমৰ নগাঁও জিলাৰ নিৰ্বাচন কাৰ্যালয়ত আবেদন কৰিছে আৰু উক্ত নথিবোৰৰ অপৰপক্ষগণে ভাৰতীয় নাগৰিক হোৱাৰ স্বাৰ্থত ন্যায় ব্যৱস্থাৰ সম্পূৰ্ণ খতিয়ান আপোনাৰ ন্যায়াধিকৰণত সাক্ষৰ সময়ত দাখিলৰ প্ৰাৰ্থনা জনাইছে।
Hmm.
My lord, in respect of our reading in school Lengrabari Prathamic Vidyalaya, my lord, it was stated in para 7, my lord, page 38, অপরপক্ষ মানিকদান ওরফে বিবির নিজর নামত উত্তর লেংরিবুড়ি প্রাথমিক বিদ্যালয়ের সরকারি প্রধান শিক্ষকে অপরপক্ষ মানিকদান পিতা আব্দুল আলী বলি বিদ্যালয়ের প্রমাণপত্র বিদ্যালয়ের সিলমোহর মারি দিয়া, আনকি উক্ত প্রমাণপত্র লাহৰী ঘাটত শিক্ষাৰ মিষ্টেক নাই খণ্ড বিষয়াৰ চহী আৰু চিলমোহৰ ইংৰাজী 21/7/2018 তাৰিখত দিয়ে। তাই নিজৰ নামত নিজৰ জন্ম গাঁৱত আৰু স্বামীৰ গাঁৱৰ ঠিকনাত চৰকাৰী গাঁও বুঢ়াই দিয়া বাসিন্দাৰ প্ৰমাণপত্ৰ আছে। তাইৰ নামত জেংৰিবৰী গাঁৱৰ গাঁও পঞ্চায়তত সচিব হৰিপ্ৰসাদ মহিৰাবাৰী খণ্ড উন্নয়ন কাৰ্যালয় যিখন নজৰুল ইছলাম কাৰ্যালয় নম্বৰ 54 সম্পৰ্কীয় প্ৰমাণপত্ৰ প্ৰদান কৰে। উক্ত অপৰপক্ষ মানিকদানৰ স্বামীৰ ঠিকনাত ভোটাৰ তালিকাৰ জৰিয়তে প্ৰদান কৰে। Even my lord, her one elder brother also deposed before the tribunal file as DW3, and one co-villager also deposed before the tribunal as DW4, my lord. They are also categorically state that she is the daughter of Abdul Ali and the resident of village Lengriburi.
No, that's the reason we say from the evidence adduced by the headmaster of the school.
Yes, my lord.
Do you think it is sufficient to prove?
My lord, there is one thing, my lord.
First of all, it's a government
Record.
lower primary school.
Yes, ma'am.
Secondly, the headmaster of the school stated that she completed her education when she studied in the year 1988.
Yes.
And as per date of entry in the admission register, her date of birth is 1st May 1979.
Yes, ma'am.
Now, when this certificate was obtained,
2018, my lord.
after how many years?
20 years, ma'am.
33 years.
30 years.
33 years, right?
Yes, ma'am.
Okay, 1988.
Yes,
So
ma'am.
it will be after 30 years.
30 years.
Is it acceptable? Secondly, this transfer certificate has the national emblem.
Yes, ma'am.
Now the headmaster himself stated
Yes.
that there is no proper pagination
Yes, my lord. That true,
of
ma'am.
the admission register,
Yes, ma'am.
and that admission register has not been proved because it's a government school.
Yes, my lord.
It has not been proved by the higher authority.
Yes, ma'am.
The certificate was not issued in the school pad.
My lord, that may not be necessary, my lord. My
Not
lord,
necessary.
may not be.
Now-
My lord.
Hmm.
My lord, when the school master himself, my lord, deposed that he bring the school register.
Now,
My lord.
উক্ত প্ৰমাণ পত্ৰ মই হাতেৰে লিখি দিয়া There is another mission destiny. There is another sentence. No. What else?
Lord, else is my lord, her brother's deposition, my lord.
Hmm.
Her brother deposed before the tribunal, my lord,
Hmm.
as DW3. And one co-villager also deposed before the tribunal as DW4, my lord.
Hmm.
We start from page 58, my lord. The brother's deposition, my lord.
Where you have mentioned it, how many brothers, sisters you have?
My lord, in my
In your
prose, my,
written statement, did you submit?
no, my lord, in written statement it was not mentioned. However, my lord, in prose, my lord, prose part, my lord, in my evidence, my lord,
Hmm.
it was mentioned, my lord.
Did you submit any affidavit in evidence?
This is not an affidavit, but it was in chief, my lord. When the my lord is under section 165 to the court, my lord, it was court who asked, my lord. Page 50, my lord. But number 2 is my Mozammil Ali, my lord. This is my brother who deposed before the tribunal.
Okay. Then
Yes, my lord. And my lord, another thing is not by initially I pointed out.
DW2.
Yes, my lord, DW2. My lord. DW2, my lord, is husband, my lord. What happened, my lord? Initially, notice was issued in favor of my husband.
Ah,
Also, my
now
lord. That's-
DW3.
Yes, my lord. DW3.
Yes.
It's sister from page 58, my lord. অপরপক্ষ মোর নিজা ভনী আমার দুয়োৰে মা দেউতা একে মোৰ দেউতা আব্দুল আলী আৰু মোৰ মাৰ নাম মালেকা মোৰ ভনী অপৰপক্ষ জন্ম লেংৰিবৰী গাঁৱত হয় মোৰ মতে মোৰ ভনীৰ মোৰ মতে মোৰ ভনী
অপরপক্ষর জন্ম
লেংৰিবৰী গাঁৱতে হয় মোৰ মতে মোৰ ভনীৰ ওপৰত কোৱা এই গোচৰ মিছা আমাৰ ভাই ককাই বাই ভনী মুঠ 10 জন মোৰ মা 3 গৰাকী, মোৰ মাহীমাৰ নাম নুৰজাহান আৰু মোৰ
মোৰ মা দুই গৰাকী
Yes, ma'am. দুই গৰাকী।
উম।
মোৰ মাহীমাৰ নাম নুৰজামান আৰু মোৰ নিজৰ মাকৰ নাম মালেকা আৰু মোৰ বাকী ভাই ভনীৰ ওপৰত বিদেশী গোচৰ নাই। মোৰ মা দেউতা 1965 চন আৰু 1970 চনত ভোটাৰ তালিকাত নাম আছে আৰু ইতিমধ্যে উক্ত ভোটাৰ তালিকাসমূহ আদালতত দাখিল দিয়া হৈছে। মোৰ ভনী অপৰপক্ষই মোৰ দেউতাৰ পৰা মাটি বাৰী পাইছে। আমাৰ এই সম্পৰ্কে যথেষ্ট নথি পত্ৰ আছে। মোৰ ভনী অপৰপক্ষ বিদেশী নহয়, তেওঁ জন্মসূত্ৰে ভাৰতীয় নাগৰিক। লেংৰিবৰী গাঁৱত মোৰ দেউতাৰ যথেষ্ট মাটি সম্পত্তি আছে আৰু মোৰ ককা দেউতা চব্দুল আলীৰো মাটি সম্পত্তি আছে। মৈৰাবাৰী গাঁৱৰ নিবাসী আব্দুল গফুৰৰ ল'ৰা হাছান আলীৰ লগত অপৰপক্ষ বিয়া দিয়া হয়। অপৰপক্ষই উত্তৰ লেংৰিবৰী স্কুলত লিখা পঢ়া কৰিছিল। অপৰপক্ষই লেংৰিবৰী গাঁৱত ভোটাধিকাৰ পোৱাৰ আগতে তেওঁৰ বিয়া দিয়া হয়। অপৰপক্ষ আৰু তেওঁৰ দেউতাই 10 বছৰমান সৰু হ'ব। মোৰ মাকক তাৰাবানু বুলিও মাতিছিল। মোৰ বয়স 10 বছৰ হওঁতে দেউতাই মোৰ মাহীমাকক বিয়া কৰাইছিল। অপৰপক্ষক কোন চনত বিয়া দিয়া হৈছিল মই নাজানো।
Okay. Now, what is his name? What is his name?
My lord, DW4, my lord.
DW3
Mozammil Haq, my lord.
Muzammil. Now, what is the name mentioned by the proceeding?
Mozammil Ali, my lord.
Own brother, elder brother.
Yes, my lord.
Anything else?
My lord, and the deposition of co-villager, my lord, DW4, my lord, page 61.
Is it from any document or personal knowledge?
Lord, he has the personal knowledge, my lord.
Personal knowledge don't do, as you know. Now, just now you have read the deposition of your projected brother, right?
Yes, my lord.
You read from the middle portion.
Yes, my lord.
More ভনী অপৰপক্ষই
মোৰ দেউতাৰ পৰা মাটি বাৰী পাইছে।
আৰু এই সম্পৰ্কত
যথেষ্ট নথিপত্ৰ আছে।
যথেষ্ট যথোচিত নথিপত্ৰ আছে। মোৰ ভনী অপৰপক্ষ বিদেশী নহয়।
তেওঁ জন্মসূত্ৰে ভাৰতীয় নাগৰিক।
তেওঁ জন্মসূত্ৰে ভাৰতীয় নাগৰিক। লেঙেৰিবৰী গাঁৱত মোৰ দেউতাৰ যথেষ্ট মাটি সম্পত্তি আছে।
আৰু মোৰ
আৰু read the name of the grandfather. মোৰ ককা দেউতা
Sobdul Ali.
ছবদুল আলীৰো মাটি সম্পত্তি আছে।
Yes, my lord.
Then how got married to her? Now exhibit P,
Yes, my lord.
that's the voter list of your protected father, right?
Yes, my lord.
Ali,
Yes, my lord.
son of whom?
Nobi Hussain, my lord.
Now who is this Sabdul Ali? Your protected brother said that the name of your grandfather is Sabdul Ali,
My lord.
but here it is Abdul Ali, a son of Nabi Hussain.
Yes, my lord.
The voter list of 1970, one Ali, let us assume it is Abdul Ali, son of Nabi Hussain. Now the school certificate, Abdul Ali.
Yes, my lord.
Who is this Nabi Hussain? When you have mentioned, when your brother have mentioned that the name of your brother is Abdul Ali. Will you able to explain? It happens.
Yes, my lord. No explanation was given, my lord. No,
So you can understand.
But my lord, in respect of reference, my lord, reference is in respect of 1966-71, my lord.
Reference.
Yes, my lord.
Are you sure?
Yes, my lord.
Office of the Superintendent of Police, Border, Morigaon, Assam, Foreigners Tribunal, number 27 of 2005, later is of 21/10/2005. The reference is not available here. The letter has been written to one K.N. Bora of Moirabadi Police Station. It has been learned that Masammat Manikjan Bibi, wife of Hassan Ali of village Moirabadi, Police Station Moirabadi, District Morigaon, is suspected to be a foreigner who entered India after 1/1/1966. So IMDT Act 1985.
And my lord, subsequent part also there, they are also mentioned 1966-71, my lord.
Yes, Mr. Karma, what do you have to say?
Yes, Lordship. Regarding that, Lordship, law has already been settled, Lordship, in the case of then petitioner's claim contended that, Lordship, a tribunal has exceeding his jurisdiction, Lordship. Regarding that, Lordship, this aspect has gone into by this honorable court, Lordship, in the case of WPC 2279 of 2021. Rukia Begum Borhuya, Lordship. Elaborate judgment has been passed, Lordship, in this case. And Lordship,
279.
yes, Lordship, 2279 of 2021. And by distinguishing earlier case passed by this honorable court, Lordship. 2279 of 2021, Lordship. Lordship will kindly see para 13.
Rukia Begum Borhia. Yes, Rukia Begum. Para 13, Lordship. Very detailed order has been passed, Lordship, in this case.
Read.
Para 13. In view of the provisions of Section 6A of the Citizenship Act 1955, Clause 21 of the Foreigners Tribunal Order 1964 would now have to be understood that once a reference is made, the reference could be whether the person concerned is or is not a foreigner, meaning thereby whether the person concerned is a foreigner who had entered the state of Assam from the specified territory on or after 25 to 1971, or he is a person who belongs to any of the other categories, that is, a person who entered the state of Assam from the specified territory before 1/1/1966 or between 1966 and 1971. No other meaning can be attributed to the reference under Clause 2(1) of the Foreigners Tribunal Order 1964, that is, whether a person is or is not a foreigner within the meaning of Foreigners Act 1946. We further take note that even if a reference is made by setting up a question whether the person had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, the reference would have to be understood to be a reference under Clause 2(1) of the Foreigners Tribunal Order 1964, that is, as to whether he is a foreigner or not. If the reference is worded whether the person concerned is a person who had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, in order to arrive at any such conclusion that the reference itself is faulty inasmuch as the decision of the tribunal upon the materials on record would be that the person concerned had entered the state of Assam from the specified territory on or after 25/3/1971. In such circumstances, the only situation that can be envisaged is that the tribunal first arrived at a conclusion of its own that the person concerned had entered the state of Assam from the specified territory on or after 1971, meaning thereby that the reference itself been answered by the tribunal. After having answered the reference, it would be an inconceivable situation that merely because the reference is worded whether the person had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, it has to be referred back to the referral authority to make fair reference now, putting up a question whether the person concerned had entered the state of Assam on or after 25/3/1971. In such a situation, as the matter would have to be referred back only after a final decision has been arrived at, and now if the reference is again made with a corrected expression in the question frame, this same may lead to further complications that the subsequent reference would be barred by the principles of res judicata inasmuch as it would be a subsequent reference on the same issue between the same set of parties where an earlier decision had already been arrived at. It is noticed that Falani Bibi Supra, the aforesaid aspect of the further implication of a corrected reference being again made, had not been gone into, and from such point of view, it can be said that the view taken therein would be par incuriam of the further consequences of a fresh reference being made.
Read para 14.
Mr. D. Mojumdar, learned Additional Advocate General Assam, has also placed reliance upon the provisions of Supreme Court rendered in paragraph 13 of its judgment in state of UP versus Ajay Kumar Sharma, reported in 2016-15 STC 289, which is extracted as below. Para 13, time and again this court has emphatically restated the essentials and principles of precedent and the stare decisis, which are a cardinal feature of the
hierarchical character of all common law judicial systems. The doctrine of precedent mandates that an exposition of law must be followed and applied even by the coordinate or co-equal benches and certainly by all smaller benches and subordinate courts. That is to say that a smaller and later bench has no freedom other than to apply the law laid down by the earlier and larger bench. That is the law which is said to hold the field. Apart from Article 141, it is a policy of the court to stand by precedent and not to disturb a settled point. The purpose of precedents is to bestow predictability on judicial decisions, and it is beyond cavil that certainty in law is an essential ingredient of rule of law. A departure may only be made when a coordinate or co-equal bench finds the previous decision to be of doubtful logic or efficacy and consequently its judicial consequence is so perturbed and erode that it finds it impossible to follow the existing ratio. The bench must then comply with the discipline of requesting the Honorable Chief Justice to constitute a larger bench.
Then what happened? Finally,
Lordship, a court lordship come to a decision that tribunal can go beyond reference lordship. Earlier, Palani Bibi's case has been discussed and Palani Bibi's case was based on Santosh Das case, lordship, decided on the basis of Santosh Das case passed by Honorable Court, lordship.
Palani Bibi, give the citation.
Yes, Lord. Lordship, Palani Bibi, WPC 7104 of 2015, Lordship. 7104 of 2015.
Then Santosh Das,
2017 to GLT 1065.
2017 to GLT 1065.
Yes, Lordship. And Palani Bibi's case is based on Santosh Das case, Lordship. Yes. Itu itu pelek.
So what happened? Was it referred to the full bench or?
No, Lordship. A later part I may not read, Lordship. A reading of the provisions in paragraph 13, para 15 I am reading, Lordship. Para 15 I am reading, Lordship. A reading of the provisions in paragraph 13 of the provisions of the Supreme Court in Ajay Kumar Supra makes it discernible that the Supreme Court has emphatically restated the essentials and principles of and precedent and stare decisis, which are a cardinal feature of hierarchical character of all common law judicial systems. The term stare decisis is defined in Black's Law Dictionary to mean the doctrine of precedent under which a court must follow earlier judicial decisions when the same point arise again in a litigation. We are of the complete agreement with the principles, precedent, and stare decisis that court must follow the earlier judicial decisions when the same point arise in a litigation, but at the same time, it is also an accepted principle of law that doctrine of per inquirium is an exception to the doctrine of stare decisis. The doctrine of per inquirium is defined to be a judicial decision which was wrongly decided because the judge or the judges were ill-informed about the applicability of the law. In the instant case, when the decision in Phalanu Supra was rendered, the further technical complication that may arise upon a fresh and corrected reference being made that it may be barred by principles of res judicata was neither urged upon nor was gone into by the court. The question whether the reference is faulty or not can only be determined after there is a decision being rendered that the person concerned entered the state of Assam from the specified territory on or after 25/3/1971, whereas the referred question was whether he entered the state of Assam between 1/1/1966 and 25/3/1971. In other words, the conclusion as to whether the reference is faulty or not can be arrived at only after the final decision has been rendered on the materials being produced, and therefore as a decision had been rendered upon the materials being produced. The same issue, if again referred back with any correction in the wording in the reference, may invoke the principles of res judicata that it cannot be referred and answered again, as it would be a subsequent reference on the same issue, which is between the same parties and was decided in a prior proceeding. In these circumstances, we are of the view that principles of per inquirium would be applicable in the instant case rather than the principle of stare decisis. In view of above, the principle of per inquirium is more applicable rather than it being the principle of stare decisis. The principles laid down in the paragraph 13 of Ajay Sharma can also be answered accordingly that the earlier decision in Phalani BB needs a further clarification to the extent that if the conclusion as regards the faulty reference can be arrived at only upon a final decision, it would be in the interest of all parties to have the final decision being converted to an opinion rather than to undergo the technicality of returning the reference, having it corrected and decided once again. From such point of view, we are unable to agree with the order dated 25/1/2019 of the tribunal. So and so. In view of such answer, we are of the view that subsequent order dated 12/3/2000 would have to be considered from under perspective, although technically the corrected reference would not be maintainable. But however, even if the earlier decision arrived at that the petitioner is a person who had entered the state of Assam from the specified territory on or after 25/3/1971 is itself a final decision, but the petitioner also deserves an opportunity to assail such final decision on its own merit. The petitioner is of the view that some further materials are also available, and so on. This is
They referred back.
yes, Lordship.
But here, in this particular case,
Yes, Lord.
Mr. Hassan,
Yes, madam.
just tell us one thing. Have you ever challenged that notice? That the notice itself is beyond the reference? Because the notice is very clear. Though there was name of the petitioner and her husband, her daughter, right?
Yes, ma'am.
It was very specifically mentioned.
The
in the
reference was challenged, my lord. Representative-
বিদেশী আইনৰ নিয়ম অনুসৰি অধিকাৰপ্ৰাপ্ত বিষয়া মৰিগাঁও জিলা আৰক্ষী অধীক্ষক প্ৰতিবেদন মতে তলত দিয়া কাৰণসমূহত আপোনাক বিদেশী বুলি সন্দেহ কৰা হৈছে। কাৰণসমূহ: আপুনি ভাৰতীয় নাগৰিক নোহোৱা স্বত্বেও ভাৰতৰ গাঁও মৈৰাবাৰী থানা মৈৰাবাৰীত অবৈধভাৱে বসবাস কৰি আছে। আপুনি কোনো পাৰপত্ৰ নোহোৱাকৈ অবৈধভাৱে ভাৰতত প্ৰৱেশ কৰিছিল। গতিকে ছাত্ৰত এই আদালতত নিজে বা উকিলৰ জৰিয়তে হাজিৰ হৈ বিদেশী আইন 64 অধীনত বিচাৰৰ বাবে আপোনাৰ ক'বলগীয়া জবাব লিখিতভাৱে দাখিল কৰিব, অন্যথায় আপোনাৰ অনুপস্থিতিত গোচৰ একতৰফা বিচাৰ কৰা হ'ব। Right?
Yes, ma'am.
Now, where is the challenge in your written statement? When did you raise that issue?
First, my lord, even in notice, my lord, it was not mentioned about the for which system, my lord, I was
That's
suspected. to
true.
be
That is
foreigner.
why you are considered as a foreigner and you have been staying illegally in the state of India
My lord,
in a particular village without any valid documents.
my position is that, my lord, at the time of filing W is that all the investigation was made. First faulty investigation, the investigation never was investigated properly, my lord. Para 2, my lord. So in my written statement, page 6, 36, my lord.
Your prayer was, গতিকে দয়ালু মহোদয়ে দয়া কৰি এই লিখিত জবাব গ্ৰহণ কৰি
Yes, my lord.
ন্যায় বিচাৰৰ খাতিৰত সাক্ষীবাদী গ্ৰহণ লৈ অপৰ পক্ষগণক জন্মসূত্ৰে ভাৰতীয় নাগৰিক বুলি ঘোষণা কৰাৰ প্ৰাৰ্থনা আৰু চৰকাৰৰ পক্ষৰ এই গোচৰ খাৰিজ হোৱাৰ প্ৰাৰ্থনা। So, in which particular statement in your written statement you have said so, or the so-called notice you have said so, so-called reply?
My lord, para 2, my lord. উক্ত নাম গোচৰ মৰিগাঁও জিলা আৰক্ষী অধীক্ষক সীমান্ত আৰু উক্ত বিষয়াৰ কাৰ্যালয়ৰ অধীনতে এফটি গোচৰ স্বয়ংক্ৰিয় গোচৰ আৰু অসম চৰকাৰৰ উক্ত গোচৰ সংশ্লিষ্ট কৰ্তৃপক্ষ সঠিকভাৱে তদন্ত নকৰাকৈ অনুসন্ধান নকৰাকৈ স্থানীয় কোনো লোকক সোধপোছ নকৰাকে আৰু অপৰপক্ষজনৰ নিজৰ পিতৃ মাতৃ ককা দেউতা আৰু আত্মীয় স্বজনৰ ভাৰতীয় নাগৰিকত্বৰ প্ৰমাণ নথি পত্ৰ প্ৰমাণ নকৰাকৈ অপৰপক্ষজনীৰ বিৰুদ্ধে মূল কাৰণহীন ভিত্তিহীন সম্পূৰ্ণ মিছা এক প্ৰতিবেদন বা গোচৰৰ ৰেফাৰেন্স ন্যায়াধীশত দাখিল কৰিছে, সেয়ে উক্ত গোচৰ খাৰিজযোগ্য।
Only because there is no proper investigation, according to you.
Yes, my lord.
But that reference is bad. Where is that?
It's, my lord, beyond reasonable point, my lord. One thing is that, my lord, basically, my lord, in the FT tribunal, my lord, there is initial stage that they did not give any access to the reference, my lord. Only after that part, when they declared foreigner, then only can he go through the reference, my lord.
I don't
When the
think so.
in notice,
don't
my lord, it was not been mentioned, my lord. It's not necessary to me to, my lord, to clarify in my WS, my lord. But, my lord, from the initial stage, I am stating that this case is false, my lord. Then there is no proper
How
investigation,
you
my lord.
prove? That's the reason. When your own brother is saying that your grandfather's name is something else,
My lord, I admit,
Sabir Ali.
my lord, there is some problem, my lord.
What problem?
My
What
lord,
problem?
but, my lord, if consider, my lord, reference,
Possible when this problem arises, when the sister is wrongly spelling the name of her own brother. Brother is saying name of his own grandfather wrongly. It happens. It happens. Large number of people. It's an open thing. Everybody you go, they will do.
my lord, I admit.
In the NRC, they have taken the name. They have taken their father, mother, brother on rent. Right?
My lord.
It's happened. happens only in that circumstance. Your sister will not able to tell you that your name is such and such Hassan.
My lord, surely.
Whether will you not able to tell you correctly the name of your grandfather?
Sure, surely.
Definitely you will. But why the proceedee wrongly said your
His
name,
grandfather name.
and why the
His
proceedee's
brother.
projected brother has wrongly named and correctly? Sabed Ali, he is his grandfather. Definitely. But not the grandfather of the petitioner. Got it?
My lord.
Anyway, you have not heard Mr. Sharma yet.
Lordship,
Yes, Mr. Sharma.
yes, Lordship, I want to relay another case, Lordship, regarding WS and Lordship regarding sudden appearance of brother, Lordship. Is it reliable evidence or not, Lordship? Regarding 2017 2 GLT 1076, Lordship. 2017 2 GLT 1076, Lordship.
What is there?
Dear Lordship, I want to rely at first, Lordship, para 12. Momin Ali versus Union of India, para 12. I may allow to reach, Lordship. Para 12. This written statement of the petitioner was wholly inadequate and did not disclose any material fact. As noticed above, it was the allegation of the state that the petitioner was a foreigner. Therefore, as per mandate of Section 9 of the Foreigners Act 1946, it was the bounden duty of the petitioner to have disclosed all the material facts which were specifically within his knowledge in the written statement, but he did not do so. Petitioner neither mentioned his date of birth nor his age. He was silent regarding name of his mother and identity of his grandparents, both paternal and maternal. He did not mention anything about his brothers and sisters or about his marital status. On the basis of such a written statement, it cannot be said that petitioner had stated anything substantial to show that he was not a foreigner but a citizen of India. Then, Lordship, para 13, it is a settled proposition of law that where a party fails to set up a case in his pleading, he would be debarred from adducing evidence in his support at the stage of trial. As a matter of principle, variance between pleadings and proof is not permissible. Lordship, then para 17, Lordship. Reverting back to the written statement, it has already been noticed that there was not a whisper by the petitioner that he had any brothers or sisters, not to speak of disclosing their names and other particulars. Therefore, the sudden appearance of Umar Ali in the witness box as a brother of the petitioner has to be looked with suspicion, and this suspicion is further fortified by the fact that in the 1997 voter list, the name of Umar Ali did not appear along with the petitioner. That appeared in Exhibit 6, Lordship. Land document, the name of Umar Ali did not appear along with the petitioner as patta holder. Therefore, evidence of Umar Ali was rightly discarded by the tribunal. In this case also, Lordship, although someone deposed before the tribunal by identifying himself as her brother, Lordship, but there is no proof, Lordship, regarding that he is the son of Abdul Ali, whose name enlisted in the voter list of 1966. And not only that, Lordship, there is no continuity from 1970 to 1997. There is no voter list has been filed by the petitioner placed before the tribunal, Lordship, to establish its continuity in the state of Assam since 1996 to 1970 to 1997, Lordship.
No continuity.
Yes, Lordship.
Why?
Means Lordship will after 1970,
70.
Lordship. Petitioner placed the 1997 voter list. of one Agupur, Solomon Nasa Hassan Ali and Manikjan.
That is not the, this is not the, not
Yes,
the
Lordship.
petition.
After 1970, what happened to his parents, Lordship? That was not mentioned anywhere, Lordship. There is no.
This is not the voter list of petitioners father.
Yes, Lordship. Yes, this is not the voter list of petitioners father. And here, petitioner and her husband name appeared, Lordship. After 1970, Lordship, there is nothing, Lordship. And only link certificate is the transfer certificate, as your Lordship already pointed out, Lordship. This certificate is not admissible in evidence because that emblem is embossed at the top of the certificate, Lordship. And apart from that, what the headmaster of the state school deposed, Lordship has already pointed out. So, Lordship, there is no error apparent, Lordship, in the opinion passed by the learned tribunal. If we consider the present age of the petitioner as deposed before the learned tribunal, Lordship, he is sometimes born in the year 1971, Lordship. Then he is eligible to cast post in the year of 1989, Lordship. But not a single voter list has been placed by the petitioner. That
Right.
is,
It is there,
Lordship.
our voter list is there on 1997.
No, Lordship.
Page 26, page 27.
Projected brother, Lordship. There
You're
is
talking
no.
about projected brother.
Yes, Lordship. DW3. There is no proof that he is the son of Abdul Ali, who was a resident of Lordship Langribari.
My lord, 1997 voter list in respect of petitioner, my lord.
I am telling about brothers voter list.
Anything you want to cite? Mr. Hassan,
My lord,
if you want to anything?
my lord, sometime may given, my lord, in
Time?
respect of 1966, 1971,
That thing we cannot look into. Any judgment you want to cite?
my lord, in respect of judgment, sometime may given. Yes, my lord.
Tomorrow, cite your judgment.
No, my lord, Monday, my lord.
We don't know whether we'll sit on Monday or not. The constitution of the bank do not.
Tomorrow may not be
So
possible.
submit by Monday, judgment,
My lord,
and your written or
my lord,
submit before him.
my lord, my lord. Right.
Heard Mr. K.M. Hassan, learned counsel appearing for the petitioner. And Mr. G. Sharma, standing counsel, Home Department, Assam, for the response number. That's for number 4, 7. Also heard Mr. H. Kuli, Mr. A.I. Ali, standing counsel, Home Department, Assam. Standing Council, Election Commission of India for the respondent number 2 and Mr. R. Talukdar, right? Government Advocate Assam for the respondent number 6. Peruse the records in original. The petitioner as well as the Standing Council from Department Assam, no, Council for the petition as well as for the Standing Council. I, Mr. Hassan and Mr. Sharma shall submit their short written argument along with the relevant citation by Monday, 8th of February. Fifth. Order is the
Now listen.
Right. Come back with it. चलिए
Yes. Deeply apply.
first council acting expert, second council is there. No representation on behalf of the petitioner on call. Sunny Council, Health Department. Okay. Respondent of others. Even for 1, Health Department. 1, 4, and 5. No representation of the respondent of others. List of control.
May I please the lordship? My lord, lordship will get the order case 64 minutes.
Where is the order?
My lord, at page 63, 64 minute. And observation at page 66, bottom minute. Page 64 minute. Sorry.
Take a seat.
My lord.
Yes, Mr. Sharma, have you gone through the rounds of review?
Whatever path, so it should pass based on the direct enrollment position.
Hmm.
Given by the SSL.
Hmm.
So the text for this test in the year 7, it was 86. 17, 8, 79. This was they want to find.
Hmm.
The report of the SS. Second,
That has been quoted in the impugn order itself,
Got
right? Then,
exact enrollment position given.
hmm,
Exact enrollment position given.
hmm,
2016,
hmm,
section 3.1 will say the enrollment shall be verified with the data as per DICE code of 2009, 10 or before.
Hmm.
As available in the records of the new park.
Hmm.
New Delhi. There shall be
you are reading which was it?
3112.
Section?
3112.
Hmm. Yes.
Enrollment shall be verified with the DICE data as per DICE code 2009, 10 or before. As available in the records of the National University of Planning and Administration, New Delhi.
Hmm.
There shall be physical verification of students, checking of records of attendance of students of last 2 years.
Hmm. Hmm.
Now, the record of the SSL. So far, I got a lordship, who said in the year 2016 and 17, the record was 86. As recorded in the new one. 17 and 18 was 17.
So, enrollment shall be verified with the data as per the DICE code of 2019 or before, as available in the records of the NUPA. There shall be physical verification of students and checking of the records of enrollments or something.
Of last 3 years.
Verification of students and checking of the records of attendance of the students of the last 3 years. This act has come into force when? From 5th of May, I think so.
Yes, my lord.
2017.
May.
So it has to be from last year's means 2014, 15, or 15, 16, and 16, 17.
My lord.
What does the record say?
Record says that SSA report submitted by the SSA
Hmm.
during the verification process.
Enrollment of 2016, 17 was 86.
86.
So we cannot have 17, 18,
Got
but it has to be up to 16, 17.
Got
Right? 86.
So 86 students for this is less than 105 for 105 students.
2011 rule says what? Eleven rules or
Rules for schedule is the fact law.
act?
It is the fact. Page number 20.
Don't go.
Page number 28.
Yes.
Schedule. B. For six class to 8 class. At least one teacher as per class so that there shall be one teacher each for science and mathematics, social studies, language. One. Number two, at least one teacher for every 35 minutes. Number three, where admission of student is above 100, a full-time head teacher and part-time instructor. Now here, this particular school, the enrollment position as on 2016 and 17 was 80. So below 100. There is three teachers, one for language, one for
How do you define B2? B2.
at least one teacher for every 30.
How many 35s are there?
Three teachers has two positions. Subject was also got teacher if it is less than 100. Where admission of teacher is above 100, that is three each. Right? So admission of teacher is above 100, then it is the full-time head teacher, part-time instructor, physical is equal to
What is the committee decided? What is the decision of the committee? Pursuant to 2017 Act, there was a committee, right?
dot.
What the committee decided?
Yes, first of all, the teacher given in this connection as per 3.1.11 of Provincial of Children, there shall be three teachers or teachers with at least one teacher each for science and social studies and language. The additional teachers were recommended in accordance with the norms and standards in the schedule under section 921 of the right to the end of the section 9. Therefore, the schedule under section 9 of the right
of the question was how to be eligible for prototype user as per Act 2017. Both the committees recommended following three features for prototype purposes as per Act 2017. Again, Viraj Mohan, who is the subject of the school. This subject supported the topic. Here, the recommendation of after Act 2017
The SSA report was on the basis of the nuclear record.
Lordship. It says so. Accordingly, SSA Assam had submitted the dice data maintained by any case in respect of the school of the
Whether SSA is a party in this review petition or not. Party, you are not representing SSA.
No,
Registry shall reflect the name of standing council SSA. In the cause list. For the respondent number 4. Heard Mr. P. K. Dekal and counsel for the review petition. Clerk state petition. As well as Mr. T. N. Sharma. Standing council 1123. For the respondent numbers 1, 2, and 3. The registry shall reflect the name of standing council SSA Assam. For the respondent number 4. And the government advocate Assam. For the respondent number 5 in the cause list. What is this matter? As and when this court sits singly. Mr. Chauhan?
Hello. My lord, in my review petition, my lord, only direction, my lord, I pray for my lord, to lordship directed the director of BTC, my lord. In place of director of BTC, my lord, it should be director of my lord, Assam.
Why?
My lord, in paragraph, my lord, 16, 17. Others are, my lord, no, my lord, there is no, my lord, only, my lord, because, my lord, the petitioner number 1 to 5, my lord, all along, my lord, within, my lord, the general area, not BTC area. Petitioner number 6, initially in the BTC area, but in 2005, he also got, my lord, transferred to general areas, my lord. That document was not there in the writ petition, page 13, my lord. Yar Ahmed, Yar Muhammad. So, my lord, all the 6 petitioners, my lord, serving, my lord, were serving, my lord, in general area, not under BTC authority. That's the only, my lord, prayer.
You retired from where?
Yes, my lord, we retire, my lord.
From where?
My lord, my lord Mangal.
Why did court to ask you to for PTC? There has to be something.
My lord, I enclose all the documents, my lord, to show lordship that we were under the, my lord, district elementary education officer, Darang Mangalde.
Yes, Mr. Sharma, please. Don't have.
73.
Do one thing. You see 74.
This is my lord to show my lord other employees, my lord, different department got my lord similar benefit.
Do one thing, Mr. Sharma. That will please say. Accepting the petitioner number 5. 6.
6 months.
He is from Udalguri. The other petitioners retired from the office of the DO Dorong or not, just let us know. As per page 73. When they, Mr. Chauhan, where is the date of their retirement? Do one thing. What? Will be better. Date of your birth,
Yes, ma'am.
date of your appointment order,
Yes, ma'am.
give us a chart. And date of your retirement from which station?
Yes, ma'am.
Give us a chart.
Yes,
We will accordingly do
ma'am.
the next date of station. Okay?
Yes.
Third, Mr. S. Sohan, counsel appearing for the review petitioner of the lead petitioner, review petition. As well as Mr. P. N. Sharma, attending counsel, elementary education. For the respondent numbers 1, 3, and 4. registry shall, for the Scenic Council name finance shown. No representation on behalf of the Scenic Council finance as per number 2. On the next date of listing of the matter, petitioners shall place their respective date of birth as recorded in their survey book, the date of joining their survey, date of where is that notification? Mr. Chauhan?
Notification.
That benefit was given.
Yes, my lord, page 74.
No. 74.
My lord, it is in the ROP itself, my lord. ROP itself, my later, my lord, I should produce the ROP, my lord.
Date of regularization of their service. Date of retirement. Yes. The date on which they retired from service. And the concerned office and place from where they retired from service.
In para 8, my lord, I have quoted the, my lord, from a ROP. A page in my.
Okay, doesn't matter. We'll look into that.
Yes.
Please give us a chart.
My lord.
We'll see. You are agree because only in the last we have considered for BTC. Maybe something was there at that point of time. We have not
Yes.
remembered at least. Give us. Please this matter. Whenever this. Okay.